Welcome back, everybody, to co-ownership. This lesson we're going to talk about the idea of severance. Now, you can really divide the topic of severance into two different distinct categories. On the one hand, you can talk about what severance is, how it works, and do a few examples of how it works. That's what we're going to do in this lesson. And then you can talk about the ways in which it works, how it works, i.e. the process by which it works. That's something that we're going to do in the next lesson when we start talking about the methods of severance, the different ways in which you can sever from co-ownership of a property. This lesson, though, like I said, is just going to talk about severance from an introductory perspective. We'll take an introduction to what severance is, get a general idea of what we mean when we talk about severance, talk about where severance can or cannot apply, where it is able to apply and where it is not able to apply. And then, as I said, in future lessons time, talk about the methods of severance. So, whenever you have a problem question on the nature of co-ownership, for the most part, you'll probably be examining the idea of severance. You'll likely be examining the idea of severance. This is something that is a very popular question for those who are setting exam questions on the idea of co-ownership. Severance is often a topic that is discussed quite a lot because it's quite a substantive topic that has quite a lot of interesting details attached to it. And so this lesson, like I said, is going to introduce this idea of severance before then talking about the methods of severance in future lessons' time. So what is severance, and what do we mean when we talk about severance? Well, it is the process by which co-owners of a property may make the decision to change their legal title to the property, which arises from a joint tenancy, to that of a tenancy in common. That's what initially what we think when we talk about severance. According to the Law of Property Act, the severance of a joint tenancy cannot happen at law. And so when we talk about the severance of a joint tenancy, it only happens in equity. This is what we see here in section 36, subsection 2, where they say that no severance of a joint tenancy of a legal estate, so as to create a tenancy in common in land, shall be permissible, either by operation of law or otherwise. But this subsection does not affect the right of a joint tenant to release his interest to other joint tenants, or the right to sever a joint tenancy in an equitable interest, whether or not the legal estate is vested in the joint tenants. So the process of severance and the idea of severance is essentially taking your joint tenancy and removing yourself from that joint tenancy to become a tenant in common, or to become part of a tenancy in common. And like I said, this is not operational at law. It can only happen when we talk about equity, and it only happens in equity. We'll explain what this means in a second. But the process of severance is very, very interesting. Essentially, when a co-owner severs from a joint tenancy, they will then have an entitlement to a distinct and separate share to the property in the form of the tenancy in common. So if you remember back to previous lessons, when we looked at the distinction between a joint tenancy and a tenancy in common, we concluded that the joint tenancy is this idea of there being a single unit of ownership, whereby you have different people who are co-owners of the property, but they together are a unitary group that represent a singular joint ownership of that property. And we noted that in order for this to be achieved, you have to have the four unities of possession, interest, title, and time. But then we also noted that when we look at the tenancy in common, there is a divisibility that is necessary, or there is a divisibility that is present in that particular relationship, such that there can be a distinct and separate share of the property that is exhibited by each of the co-owners of that property. And we also noted that when we talk about the tenancy in common, there is only the requirement of the unity of possession. The other unities are not required. They are not necessarily they're not necessary, should I say, for the existence of a tenancy in common. So if we had a scenario where you have a joint tenancy, which remember is limited in law to 4, okay, there has to then, and somebody wants to make the decision to sever, what that decision is going from being a joint tenant, going from being somebody who is part of a greater whole, part of a greater group that all represents a unified group of ownership, to having a distinct and separate share of the property as they devolve from being a joint tenant to a tenancy in common. Now, this is a process that can only happen in equity, okay? It can only happen in equity. It does not exist at law, owing to Section 36(2) of the Law of Property Act. So, when we think about this, it says here that no severance of a joint tenancy of a legal estate so as to create a tenancy in common in land shall be permissible, whether by operation of law or otherwise, but this subsection does not affect the rights of a joint tenant to release his interest from other joint tenants, etc., etc., etc. It can only happen in equity. It cannot happen in law. Let's take the following example. Let's see what I mean when we talk about the process of severance, and then we'll get to the methods of severance in the next lessons. Well, if we have three people, person A, person B, and person C, and these were all joint tenants in the property, and they hold the property on trust for themselves as beneficial joint tenants, we have this relationship. They have rights in law as a joint tenancy, and they have rights in equity as a joint tenancy. Okay, you have A, B, and C, both joint tenancy. Remember, when we think about rights in law, okay, rights in law in co-ownership can only ever be exhibited through a joint tenancy. However, rights in equity can be either a joint tenancy or a tenancy in common. So if we're talking about rights in law, you're talking about a joint tenancy. If you're talking about rights in equity, then you're talking about either a joint tenancy or a tenancy in common. In this particular example, A, B, and C are all joint tenants in law, but they also hold the property on trust for themselves as beneficial joint tenants, i.e. they have rights in equity as well. What about then when we see the decision to sever? Let's say C goes and says, I want to sever. Okay, we'll talk about how they may go about that process in future lessons' time, but let's just say for now we know that they make the decision to sever. This is what happens, okay? We still have the same rights in law. A, B, and C still have the same rights in law, and they are still joint tenants in law. This is obviously because severance does not affect legal title, as per Section 36(2) of the Law of Property Act. But the rights in equity are a little bit different. You have A and B on this side here, and then you have C on this side over here. The reason why this has happened is because what has happened in equity is that the joint tenants have been split. You have the two joint tenants of A and B, the people who've decided not to sever, but then you have C over on the other side. And that's because C has decided to sever and has reduced their rights in equity from a joint tenancy to a tenancy in common, thus therefore representing a distinct share. So when we talk about law and the rights in law, there is no difference. Severance only is effective at equity, and so it does not make any sense to suggest that this happens in law as well. We know this from Section 36, subsection 2. So when there is a decision to sever in equity, you no longer have a joint tenants with all three parties. You have A and B on the one hand being joint tenants, they're representing a distinct single unit of ownership, but you then have a tenancy in common, this being represented by C. Welcome back everybody to our studies in land law. In our continuation on the issue of co-ownership, I want to talk in this lesson about the methods of severance. So we discussed severance in the previous lesson, and we discussed what it was, what it entails, how it works. This lesson is going to outline at least, we'll recap what we mean when we talk about severance, and we will then also outline the process of identifying the different methods by which severance takes place. And so this really comes from the case of Williams and Hensman, something that we'll talk about in this lesson as well. But like I mentioned, the previous lesson spoke about the concept of severance in relation to the idea of co-ownership. We talked about what severance was and how it works. And in this lesson, and over the next few lessons, we're going to spend some time talking about how severance happens, the different methods by which severance takes place. So as a basic recap then, what is severance and how does it work? What is the process by which severance takes place? If we see three people, okay, who are all joint tenants of a property, A, B, and C. And they also hold the property on trust for themselves as joint beneficiaries of the tenancy. We see that what we have is rights in law, which exists in the form of the joint tenancy, and A, B, and C. We also have rights in equity in the form of a joint tenancy, given the fact that a joint tenancy can be either in law and in equity. So this is what we get so far in terms of the process of a joint tenant, the process of co-ownership of property, shall we say. And then we go through the process of severance. Let's say that the third person, that C, decides that they want to sever. They want to sever their interests and to become a tenancy in common. What happens here is that at law, nothing happens. Severance does not affect legal title. A, B, and C remain joint tenants in law. But in equity, we see a division. We see a division between A and B on the one hand, who have not severed, and C, who has. And what we see here is that A and B remain joint tenants in equity, but that C turns into and becomes a tenancy in common in equity. And so this is really what the process of severance involves. Now, the methods of severance are quite numerous. There are a number of ways in which severance can take place, all of which are outlined in the case of Williams and Hensman from 1861. This was a case that concerned some money which had been bequeathed to be invested in stocks. 8 children were involved in this, in the money that was bequeathed at the point at which somebody had died. All had consented to the money being invested into a mortgage fund. A number of things would then occur in terms of, in relation to the children's relationship to the money specifically, some of them being too young to end the trust, for example. And the question for the court essentially was whether the beneficiaries of the trust were still being co-owned under a joint tenancy, or whether severance had taken place at any point during this particular process. And the court outlined, and in essentially trying to answer this question, to ascertain an answer to this question, they had to think about, well, how does severance take place? And they outlined the different methods and modes of severance, all of which exist to this day. The methods of severance are as follows. We have written notice, which is often considered to be the most simple and easy to understand method of severance. You have the act of operating on one's own share. So essentially, in layman's terms, what this means is, where you are a joint tenant, you are acting as a single cohesive unit, as what we've been talking about previously in our lessons on co-ownership. And so by acting on your own share, you act in a way, you perform some kind of action that would suggest that you are acting as a shareholder of the property, which would imply that you are not acting as a cohesive unit, which implies that you have severed to a tenancy in common rather than a joint tenancy. There's also mutual agreement between the parties for one of them or for all of them to sever. And then you have mutual conduct, which is the sort of similar element of this, where rather than it coming into an agreement, it is just the conduct of everybody involved in the process leads to the conclusion that people have severed. And then you have the idea of unlawful killing, which is, of course, a method of severance that I'm going to spend very little time examining because it's very easy, and we'll touch on that right at the end of our lessons, talking about the methods of severance. Welcome back, everybody, to our studies in land law, specifically our conversation on the issue of co-ownership. This lesson is going to carry on talking about severance, looking at the first method by which severance takes place as part of the Williams and Hensman list that identifies the various different methods of severance. This is called written notice, and is probably the most common, or one of the most common forms of severance. Of course, things like unlawful killing being one of the least common methods by which severance can take place. We'll talk about the first main method in this lesson, arguably the most commonly used method of severance. And we're going to begin with the Law of Property Act from 1925, because Section 36(2) identifies a little bit more information in relation to the idea of severance and the various different methods by which severance can take place. It says, and I quote, "Provided that, where a legal estate not being settled land is vested in joint tenants beneficially, and any tenant desires to sever the joint tenancy in equity, he shall give the other joint tenants a notice in writing of such desire. This is essentially giving us an indication of how severance takes place. Now, this is not the only method by which severance takes place, as we've noted from the previous lesson, but the Law of Property Act gives us an indication of how written notice is to be essentially understood through the process of severance. It's also a very nice way of understanding what severance means in this particular passage. It is talking about where you have a legal estate that is vested in joint tenants beneficially, and then you have a tenant who wants to sever the joint tenancy in equity. Remember, it can only happen in equity when you go from a joint tenant to a tenancy in common, since that this does not affect the process or the rights that exist at law. And then they go on to say that he shall give the other joint tenants a notice in writing of such desire. And so, written notice is a useful process for severance, since it does not require the consent of the other parties, in fact. So unlike things like mutual agreement and to a lesser extent mutual conduct, the idea of written notice doesn't require that everybody else has to agree to it. You can just say, look, I'm going to sever. I don't care if you want me to stay or not, or want me to remain as part of the joint tenancy or not. It is also a process which can be achieved unilaterally, so long as written notice is actually delivered in accordance with Section 36(2) of the Law of Property Act. Then it doesn't actually matter if, like I said, the other people consent to the process by which the severance is happening. They can unilaterally sever, and it's not up to the other joint tenants. We can illustrate the point of severance by way of written notice from looking at the 1969 case of the Draper's conveyance. This case illustrates the format of a written notice. So, Section 36(2) doesn't really give us much in terms of how it should be formatted. It just literally says that he shall give to the other joint tenants a notice in writing of such desire, the desire to sever. Now, does this writing have to be by way of a deed? Does this writing have to be delivered by hand to the particular people? Does it have to be posted? If it is posted, does the postal rule apply in terms of severance? All of which are methods and questions that we need to think about. Simply put, it does not have to be a particular form. So it is actually quite vague and quite broad as to the extent to which written notice may apply. Nor does it have to say that it is written notice to be found in accordance with Section 36. So even if it doesn't say this is a notice to sever, even if it is just implied that this is a notice to sever, then this would constitute severance on the basis of Section 36 anyway. Written notice in question for this particular case was actually that of a court summons for an order for sale for a property that was distributed by somebody's wife. Her husband had died before the order had been granted, and so as a result of which the question of severance was at issue, whether or not severance had occurred. It had been held by the High Court that both the summons, in addition to the affidavit which was also constituted in relation to the summons, meant that it was written notice for the purposes of Section 36. And so for this particular reason, the wife had successfully severed from the property. So given the fact that notice needn't be in any particular format or any particular context, it's quite vague and quite broad as to what notice may actually constitute. It doesn't even necessarily have to say that this is written notice to sever. Who must therefore receive written notice? Who must be on the receiving end of the written notice? Well, notice can exist in many different forms, and simply put, the only requirement is the requirement that is cited in Section 36(2), which is, of course, that the notice is made in writing. So who has to receive the notice? That's the next question. Well, the notice must be served to all of the other joint tenants in the property. So the people who have to actually get the notice are the people who are the other joint tenants. It must be delivered either personally or at their last known place or abode or business. Place of abode, or business. And so that's simply the only requirement in terms of receiving the notice. Where the severer has actually issued the notice in the post, there needs to be evidence that the notice has actually arrived. Now, this is quite interesting, because what this does is represent something of a shift away from what is considered in contracts as the postal rule. For those of you who haven't studied contracts yet, or maybe haven't gone on our lessons looking at contracts, the question here is relating to an offer and an acceptance in the law of contracts. You have an offerer makes an offer, and then the person has to accept the offer. If they have accepted the offer by writing and through the post, acceptance of the offer, and therefore the binding authority of the contract, takes place at the point at which the letter had been posted. And there are various different cases where a letter is posted, but then people go on postal strike, or it doesn't get received. It isn't received for another week or so, and then the person whose property, for example, they were selling to this person, then goes on to sell it to another person, and then the question is whether or not they breached a contract by doing so. The answer is so long as the letter was posted and was in the sort of system of the Royal Mail, that therefore means that the acceptance has taken place. Written notice in this regard, though, is a little bit different. Written notice doesn't require this. Written notice, in fact, requires a little bit more. It requires that there is evidence that the notice had actually arrived. And the case of Kinch and Bunyard from 1998 gives us an illustration of this point. When notice to sever is sent by post, unlike the postal rule in contract, it is served at the point it is received, not at the point when it is sent and put in the letterbox. Again, this was a case which involved a notice to sever, as the rest did. The severer in question changed their mind before the letter had been opened, and so it was held by Lord Neuberger that notice was served at the point at which the notice was put in the letterbox of the receiver. And so the question of whether or not they were valid and whether or not severance had taken place is actually something of an irrelevant question, really, because simply put, after the notice had been, the letter itself had been put in the letterbox of the receiver, anything that happens, in this case the severer destroyed the letter, is irrelevant to this fact. Severance had taken place at that point. So in the previous lesson, what we did was spend some time talking about the concept of written notice as a process, as a method by which severance can take place. This lesson is going to talk about the next of the major methods by which severance can take place, as per the case of Williams and Hensman, this being the act of operating on your own share. So thus far we've been exploring the different methods of severance in relation to the co-ownership of land. Previously we looked at the process of severance by way of written notice. This lesson, as I've said, we're going to talk about the process of severance by way of operating and acting on your own share. What does it mean to act on your own share, or to operate on your own share? Well, it's essentially the process whereby a joint tenant does something which irrevocably derogates their right in the joint tenancy. So, if you remember back to previous lessons when we talked about the idea of the joint tenancy, and specifically the distinction between a joint tenancy on the one hand and a tenancy in common on the other hand, we noted that what is important to remember is that when you talk about a joint tenancy, all of the co-owners of that property act as a single cohesive unit. They are all joint tenants, and they are joint tenants of the property. But when we think about the tenancy in common, this is really where there is individualized shares. You can divide people up in a tenancy in common, which you couldn't do in a joint tenancy. And so if you act in a way which implies that you are not part of this cohesive unit, then you are implying that you are not part of the joint tenancy. And so by this implication, you can sever your interests. So it is essentially severing through actions, and by severing through actions, what you do is you essentially do what is required for severance, or do what is necessary in the process of severance, which is, of course, becoming a tenancy in common. If you act as if you were a tenancy in common, then you have severed by acting on your own share. So this is really what severance by acting on one's own share refers to. But what kind of acts do we actually require in order for this to operate? What does require to constitute operating on one's own share? Well, there are a number of acts which could be implemented and could be argued to be an act which constitutes severance. The general principle and the common thread that threads all of these acts together is the view that the act itself is irrevocable. Okay, it is something that cannot be reversed, and therefore we can unsever our interests. So, to alienate with a joint tenancy, the party is severing. The party who is severing will simply sell or dispose their rights under a joint tenancy. This is by way of alienating a joint tenancy or alienating with a joint tenancy, alienating your relationship to a joint tenancy. And so as a result of which, what you are doing is you are severing by acting as a tenancy in common. If a joint tenant, for example, enters into a contract to sell their rights, then this will effectively represent severance from a joint tenancy on the basis of their decision. That contract to sell their rights doesn't necessarily have to include a clause or a provision or a point that says this is going to be a severance. We are going to sever, you're going to sever your joint tenancy or your interest in the joint tenancy and become a tenancy in common. That's not what this particular thing does. That's not what it represents. Because simply put, the act of selling your rights is by and large and in and of itself something of a severance action, an action of severance. And we can refer back to the 1969 case of the Draper's conveyance that we looked at in the previous lesson. This was the case where an individual had given written notice to sever, and then they changed their mind and they tried to get the letter that they had given written notice from away from the person to whom the severance was going to be delivered, or the notice was going to be delivered to. Essentially, what we have here is this case simply illustrates that the commencement of litigation against the other joint tenancy could be sufficient to sever on the basis of operating on your own share. So there is an argument, okay, that when you do litigation against somebody, if you go into litigation with a joint tenant, then this could constitute severance by way of operating on your own share. But this could arguably not be irrevocable, since the commencement of litigation does not have to result in an outcome which would constitute a severance. So it sort of challenges the basic conception of acting and operating on one's own share, given the fact that what we have here is an example of something that may not be irrevocable. Note that the general principle of an act which constitutes a severance would be an act which is irrevocable, but this case sort of points in a different direction to an extent. But what the Draper's conveyance shows us is that if there is a prerequisite intention to sever, and this intention was present at the start of the process, then this would be sufficient evidence to show that a severance has taken place, regardless of even if it wasn't necessarily an irrevocable act itself. Welcome back, everybody, to our studies in land law. What we're going to do in this lesson is carry on talking about co-ownership, talking about the issue of severance, talking about the methods of severance, focusing on this idea of mutual agreement. So far, this is the, as a point of note, this is the penultimate lesson on the subject of severance. We're talking about the concept of mutual agreement as a method of severance. What we mean by this is essentially the ways in which severance can take place. We know that from previous lessons that we've looked at the first two main methods for which severance takes place. There's acting on your share, which is essentially the process of going from a joint tenancy to a tenancy in common, will essentially involve going from acting as a cohesive group in the co-ownership to acting as joint tenants with separate shares. So if you act in a way that implies that you are a tenancy in common, then this will have the effect of severance. And then you also, of course, have the concept of notice, the idea of providing notice to the other joint tenants that you are going to sever, your intention to sever. The last two main methods of severance are mutual agreement and mutual conduct, with the final one being forfeiture. With the final one being I forget the name. Basically, where you commit the homicide of an individual, and that has the effect of severance, owing to the fact that you can't benefit from your own crime. Simply put, the idea of mutual agreement is one that is very easy to understand. As the name suggests, if the parties to the joint tenancy mutually agree to sever, they will be sufficient to establish the severance of the property. Simple as this. There are, of course, a number of conditions attached to this. The conditions for a mutual agreement are as follows. In order for the agreement to be mutual, it must be made between all of the beneficial joint tenants of the property. So this really concerns itself with the mutual part of the idea of mutual agreement. It has to be all of the beneficial joint tenants of the property. There's not necessarily any specific requirements as to the format of the agreement, so it could be satisfied through an oral agreement, an oral understanding, a conversation essentially about severance. It could be satisfied through written, some kind of written agreement, some kind of written notice that has been established. Either way would actually suffice, because essentially, it is representative of the wills and the wishes of every single joint tenant to the property. If this is in writing, then the writing need not be enforceable, but it does need to be a fixed agreement, not subject to any kind of amendments. This is one of the main requirements for the mutual element of the mutual agreement. And we can illustrate this in the case of Burgess and Rawlsley from 1975. In this case, the defendant and the claimant's father had both bought a house, both providing 50% of the asking price each, so half and half essentially. There was a dispute which arose around the promise made by the defendant to sell her shares to the claimant's father. When the claimant's father died, the claimant then took up the dispute. So this was a case involving the claimant and the defendant, of course, but the claimant was essentially the child of the claimant's of the father, who was the original purchaser of the property. The dispute carried on. The father died, and then the dispute carried on under the child when the claimant's father died. The court held that the beneficial joint tenancy had been severed by way of oral agreement. This was an oral agreement which was made between the defendant and the father of the claimant. And so the result here was, by way of mutual agreement between the parties on the joint tenancy, there was a clear indication that there was an intention to sever. There was a clear mutual agreement for the severance of the property, and as such, the property had been severed. It's important that we think about intention to sever, not necessarily requiring any formalization in the process of mutual agreement, i.e. there not needs to be any kind of deed. It doesn't need to be written in a particular way. It could be orally agreed upon, or it could be written down and agreed upon. These are all the sort of the lacking of formalization requirements in the process of mutual agreement. The thing that is required is that there is clearly an intention on the part of the parties who are present to sever, and this has to be shown in either the words or the decisions of the parties. This may be expressed. There could be an expressed intention to sever, which is obviously very, very easy to ascertain and very, very easy to understand, but it could also be an implied intention to sever, a little bit more difficult to ascertain whether or not there was an implication that severance was taking place. It must be an intention to sever, and it must be a common intention to sever. These are the two things that need to be noted. An intention to sever firstly must exist, but this intention to sever must also be common to all of the parties in the joint tenancy. Remember, this is mutual agreement. This is an agreement between the parties to the co-ownership for an intention to sever the property. In this final lesson on the subject of severance, I'm going to cover and focus on the last two methods of severance, spending most of our time on the penultimate method of severance, which is, of course, mutual conduct. We will then touch on the issue of homicide being a method of severance as well. The reason why it's not going to take its own lesson is because it's relatively trivial, it's relatively easy to understand, and it makes sense. But for the most part, we're going to be focusing on the idea of mutual conduct as being the final method of severance. Like I said, briefly touch on homicide at the end of this lesson. Quite straightforward and quite rare, in fact, in circumstances where the question of severance is being asked. Fundamentally, it is a straightforward and very easy to understand and very uncontroversial part of the law. Simply put, you kill somebody for the intention of benefiting from the co-ownership, you have then had the result of which would lead to you severing from the property. So mutual conduct is very similar to mutual agreement in the sense that it has to be done mutually, simply put. It has to be, it's an agreement that is made between the joint tenants. But it's where there is not an express or an implied indication to sever the property, like with mutual agreement. As the beneficial joint tenants, there can still be the achievement of severance, though, through the mutual conduct of the parties. So it can be implied that through the conduct of the parties, severance still takes place. This is where we infer from the conduct of all the parties that their joint tenancy interests ought to be treated as tenancies in common. And so, as a result of which, the easiest way to infer this mutual conduct that severance is desired is if it is clear that the intention of the parties indicates that the right of survivorship should no longer apply to them. This is the easiest way to, through mutual conduct, determine that severance has been at least achievable and desired, and at least wanting to be ascertained. Now, what is the right of survivorship? This is actually something that we haven't touched on yet in co-ownership. It's very, very important, but it is also obviously very important to the issue of severance and mutual conduct. It is something which essentially exists in circumstances of the joint tenancy. If one of the co-owners in a joint tenancy were to die, then that co-owner's interests will automatically pass to the surviving co-owners in law. This is known as the right to survivorship, or right of survivorship. It is to essentially pass those rights over to the other surviving co-owners in law. An illustration of this point can be seen in the case from 1970, the case of Greenfield and Greenfield. Fundamentally, in this case, the parties in the joint tenancy had made physical separations in the property. So what they had done was they divided physically their shares of the land. Now, you might think that this is actually sufficient to imply through either mutual agreement or mutual conduct that there is a severance of the property. Remember, what severance is essentially the process by which a joint tenancy in equity can go from a joint tenancy to a tenancy in common, and the way in which that happens is that you go from acting as a joint holistic group, a single unit of ownership, to owning individual shares of that property. So essentially you go from being an indivisible unit to a divisible unit. The parties to the joint tenancy had made physical separations on the property. So given this fact, surely this means that there was an intention to sever. On first consideration, you might think that severance is implied through the conduct of the parties. However, what is very important here is that despite the fact that there was the division of their shares in the land, at least a physical separation of their property, the right of survivorship was not only still active and present, but it was also agreed upon by all the parties to be active and present. You can't adhere to the right of survivorship or maintain and have a desire to maintain the right of desireship and also wish to sever the property, because the right of survivorship obviously does not work and does not operate in a tenancy in common. So as a result of this, the fact that the right of survivorship was active and present, as agreed by the parties, meant that the severance could not be implied through the mutual conduct of the parties. So it shows that the right of survivorship, of course, is a very, very important element of this area of the law. When we think about the final method of severance, so this is the final method of severance. Remember, we have had the 5 general methods of severance. You have notice, giving written notice to the particular other joint tenants of your intention to sever the property or sever from the property. You have acting on one's own share. So essentially acting in a way which implies that you have gone from a joint tenancy to a tenancy in common, which would of course be acting in a way that suggests that your joint tenancy is divisible, is therefore you're no longer a part of a cohesive indivisible unit, which is what a joint tenancy would require. That is the second method of severance. Third method of severance was looked at in the previous lesson. This is the method of severance which requires you to essentially by way of mutual agreement, come to a conclusion among all of your joint tenants that you wish to sever, that there is a severance that is going to take place on the property. This can either be expressed or implied. And then finally, there is the implication through mutual conduct, which is often cited as being an indication on a part of the joint tenants that the right of survivorship no longer is effective or operationalized among those joint tenants. The final method of severance is therefore homicide. This final method of severance essentially tells us that if you are a joint tenant with a beneficial interest, you cannot unlawfully kill another joint tenant in order to benefit from the right of survivorship. Remember, in the right of survivorship and under a joint tenancy, the right of survivorship will apply, and it will inform us that where there is the death of one of the joint tenants, the other joint tenants may take up the right of surviving through that property, essentially the right to take up that property. So if the right of survivorship applies and you are a joint tenancy and you decide that you are going to unlawfully kill another joint tenant for the benefit of being able to essentially benefit from the right of survivorship, being able to take their shares in the property, then this is of course unlawful. The death of another co-owner causes their interest in the property to be taken by you would not actually suffice. And so the result of this means that when you unlawfully kill another joint tenant with the view of essentially benefiting from the right of survivorship, you have effectively severed your interest in the property. There is a severance of the interest as a result of that conduct.